Good evening, ladies and gentlemen. The legal principle in this country is that you're innocent until proven guilty. You can knock on the doors of every court and seek reprieve if you feel wronged by the system. But in the case of narcotics, it is for the accused to prove that he is not in possession during the trial, which means that you're guilty until proven innocent. And that's exactly what has led to Aryan Khan spending 12 days in Arthur Road jail. For all those who have not been following the case closely, let me give you a ready reckoner of the case, and then you can judge for yourself which direction this case should be going or will be going in. Today, a special NDPS court in Mumbai denied bail to Aryan Khan after finding merit in the argument made by the Narcotics Control Bureau. The WhatsApp chats that the agency has been pointing to as evidence prima facie reveal illicit drug activities, held the court. In fact, they also went on to say that there were no grounds to believe that the applicants were not guilty. Now, the NCP's counsel cited the Riya Chakrabarti case as precedent. More specifically, her brother's case. Shouvik Chakrabarti was also denied bail because he was a link in the chain of drug dealers. In his case too, there was no recovery made from him, but the co-accused had commercial quantity of drugs on them. So where does that leave Aryan Khan? His legal team has now moved the Bombay High Court against the special court's order denying him bail, but it's going to be a long drawn-out process because the court will hear the NCB's arguments in the case from scratch and then set a date for hearing Aryan Khan and his lawyer's sides. So does this case have legal legs to stand on in a higher court? Aryan Khan has been booked under Section 29 of the NDPS Act, under which if one is found guilty, the other co-accused will also be punished. The NCB has also applied Section 37, under which no accused shall be released on bail or on his own bond. So are we setting a new precedent where jail becomes the norm rather than bail, at least in cases of drugs consumption, usage and linkage? Listen in to what legal and former Solicitor General Harish Salve told me on the Newshour just last week.
आज अनफॉर्चुनेटली एक हमारे सिस्टम में एक पॉपुलिस्ट कल्चर आ गया है और उस पॉपुलिस्ट कल्चर का सबसे ज़्यादा आपको प्रेशर दिखता है सबऑर्डिनेट कोर्ट्स में और कई बार हाई कोर्ट में। जेल कहीं भी और खास करके इंडिया में एक लाइफ ऑल्टरिंग एक्सपीरियंस हो जाता है और अगर आपने इसको बाद में एक्विट कर दिया तो इस बच्चे को जो ट्रॉमा हुई है, और ये इसके लिए नहीं कह रहा मैं किसी के लिए भी कह रहा हूँ, वो जो राणा कपूर की फैमिली को जो ट्रॉमा हुई है या किसी गरीब आदमी को जिसको गलत कारण से पकड़ के अंदर ठूस दिया और 6 महीना अंदर रखा है, उसका परिवार बर्बाद हो गया है और आपको टाइम नहीं मिला उसका बेल सुनने के लिए, आप उसकी वो जिंदगी वापस कर सकते हो क्या? बेल नॉट जेल रूल होना चाहिए। जुडिशरी को एक मिशन पे चले जाना कि हमको सब गलत आदमियों को अंदर करना है, ये जुडिशरी का काम नहीं। तुम्हारा काम है कुर्सी पे तुम बैठे हो, जो तुम्हारे सामने एविडेंस है उस पे केस बनता है सख्ती दिखाओ, उस पे केस नहीं बनता है खत्म करो। प्रिंसिपल क्या है? प्रिंसिपल जो सुप्रीम कोर्ट के जजमेंट में है वो लगाओ। ये नहीं कि दिल से अपने सोचो कि भाई ये कुछ ना कुछ तो होगा इसमें, वो जुडिशरी का काम नहीं।
And that brings me to the legitimate question on the Newshour tonight. Is jail, not bail, becoming the new normal? That's the question, and that's the debate. Aryan denied bail. That's the hashtag and the debate on the other side.
You're watching the Newshour at 9. Debate number 1 on Times Now, Super Prime Time.
First up on the Newshour tonight, I have The legal eagles, Pinky Anand, senior advocate and former ASG, taking on Majeed Memon, senior lawyer as well as NCP senior leader and Rajya Sabha member. I want to ask you, Majeed Memon, and I want to begin from where Harish Salve left it off last week. He said bail is the norm, not jail. But what we are seeing here in the Aryan Khan case, even though no drugs were recovered from Aryan Khan, the fact is he continues to be in jail for the 12th day and in the custody of the NCB for the 17th day. Do you believe that judges, especially in subordinate cases, subordinate courts are now taking a very populist view of how law should be interpreted?
Well, Navika ji, I will make a slight correction to what you have said a bit earlier before Harish Salve came on the scene. Because you have been repeatedly saying, twice or thrice you have said it, that probably bail as a rule is gone and jail as a rule is the new norm. I don't think this is a correct statement. Let me make it very clear.
He said in drug cases,
No, drug cases, it is there from the beginning. It is not new idea. The day NDPS was legislated, there was prohibition to bail. And this is nothing new. Let me tell your viewers, and it's a kind of a legal education for all of us, that there have been stringent statutes like TADA, POTA, UAPA, MCOC Act, NDPS Act. These are all laws where bail is not rule, but jail is rule. Yet those laws have been functioning and the society is still believing that Article 21 of the Constitution of India, the apex law, right to personal liberty, stands above all these statutes also. And therefore, if one carefully reads the provisions of bail becoming difficult in matters like NDPS, as we have got on hand, there are also safeguards provided against false encroachment on personal liberty, and therefore bail is being granted to a number of people even under NDPS Act in spite of bail not being rule. Let us also remember that initially, if an accused is arrested, remember this principle doesn't change at all. This is the spirit of our criminal jurisprudence, that you are not to be kept in custody pending trial as a part of punishment. This is very important, must be borne in mind. Your arrest is necessary only to make you face the charge. Then you have to be state guest for some time, either in police custody or in judicial custody, unless there are exceptions that if you are accused of an offense punishable with death or imprisonment for life, there is overwhelming evidence against you, then the court believes that your release is hazardous to the society, you are a criminal, you will become a threat to the safety of society. Only in such cases bail can be refused. Now let us come back to Aryan's matter. In just 2 minutes I will take. There are allegations that he is involved in conspiracy in drug trade. Well, that is based upon NCB's bringing forward certain chat, certain conversation with somebody else. Now, this chat record is a very weak type of evidence inherently, and it is hardly acceptable by the court during trial. And it needs to be having some kind of corroborative material, which incidentally, in Aryan's case, NCB has not been able to place before even the learned special judge. In any case, the learned special judge has exercised his discretion. Now, Aryan is in custody. It's a setback for Shahrukh and Aryan, but it is provisional. High Court is going to hear this matter in greater detail, and High Court has wider powers, and High Court will appreciate that even above NDPS or any other stringent law, there lies apex law, Article 21 of the Constitution of India. No person shall be punished except by due process of law.
According to Majeed Memon, the NCB hasn't been able to give any corroborative evidence other than talking or mentioning about the WhatsApp chats. Despite that, the judge in his judgment has said that Aryan will not be given bail. Is this an interpretation of law that will stand the scrutiny of High Court, number one? And number two, The question many are asking tonight is Aryan Khan paying for his celebrity status? Is he facing this wrath of the court because everybody thinks they can make an example of a celebrity?
You know, you have interesting questions, and I quite like the discourse that Majeed Memon had to say on the subject of NDPS and bail and not jail as a general rule, and how it follows from the general rule of personal liberty. I mean, there's no denying any of these features. The fact is that we do want to lean towards giving bail rather than keeping a person behind bars. But you are looking at a case at hand. Every case is distinct on its own. So you're talking about the current case where Aryan Khan has been put behind bars and is facing this entire charges of NDPS, of consumption, of possession, of abetment, of conspiracy. And in these circumstances, the question of bail that is coming up before the Sessions Court, and which has ultimately the special judge, who has ultimately rejected the bail plea on various grounds that came forth. Now, just let me take one or two arguments that Majeed Memon had to say and try to take it further. You have the question of whether there was possession and question of conscious possession. The law in NDPS requires conscious possession. So the interpretation of conscious possession, as in the present case, it was not found maybe on Aryan, but on Arbaz, it was found, and that it was admitted that it was for the use of both Arbaz and for Aryan. This has been the admitted position as far as the judgment records it, and this is the submission as far as the prosecutor is concerned, which has been conscious possession. Second, do you have a prima facie case? The court has based its prima facie case finding on the basis of, yes, the recovery of the drugs as it was, the rape party where everybody was together and everybody was arrested. The third feature being the WhatsApp chats, which we are not talking about evidence for the time being, whether it's reliable evidence by itself or not. Of course, Majeed is right. It would require corroborative evidence, particularly as right now it only indicates as to the conspiracy between Aryan and other people, including Arbaz and some other drug peddlers, where the situation is of conspiracy. But that is something which has to be tracked down, and that is one of the principal reasons why bail would be denied, because you have investigation which is going on and you need to connect the dots and to ultimately bring the culprits to book. And one of the reasons for denial bail, incidentally, principal grounds, is when investigation is going on and you need to put together the dots together so that you can get the culprits there. I repeat that only for the sake of emphasis. So between each of these features, you find that in the NDPS Act, what you do require and what has to be established is there is a prima facie case, there are reasonable grounds to believe that the accused has committed the offence, you have conscious possession, and these by and large, aside from the fact that investigation is happening, the accused may flee from the trial itself. You might have witnesses who are tampered, as in very important cases, and in other cases you find by and large there is a question of at least threat of witnesses being tampered with. In these circumstances, the bail has been denied. So this is my base.
Witness tampering का सवाल तो तब आएगा जब witness मिलेगा. Witness तो भाग गया. Majeed Memon साहब, witness तो भाग गया.
नहीं, I'm sorry. May I add on here? The question is, you are right to catch the witness also. The tampering witness, you're right.
The NCB can't catch the witness, so Aryan Khan will sit in jail. Majeed Memon, explain the law to me. I don't understand it. But if I had a child that age, I would be asking, where is the witness? What witness is Aryan Khan going to tamper? When the NCB cannot tamper the witness, they can't find him.
Very rightly pointed out. Navika, please give me a couple of minutes.
Last line, which is fair enough.
Just give me a couple of minutes.
Find the witness.
Pinky, just 1 minute, Pinky, I will explain. देखिए, नविका जी, आपके व्यूवर्स के साथ में हम एक बात कहना चाहेंगे कि हमें एक चीज को समझने की जरूरत है कि गिरफ्तारी क्यों की जाती है. गिरफ्तारी सजा का हिस्सा नहीं होती. Remember this. Arrest is not a part of punishment. Arrest or detention in custody is not punitive in law. Remember, it is for certain purposes. Now, what are those purposes? I will enumerate. It includes, even in case of NDPS and all other laws, I am talking of the Apex Law, Article 21 of the Constitution of India. No person shall be deprived of his life and personal liberty except by due process of law. This is what Article 21 says. And this is above everything else. No statute below can survive if it clashes with that provision. अब आप देखें, कि गिरफ्तारी क्यों की जाती है। गिरफ्तारी की वजह ये होती है कि तफ्तीश के लिए इन तफ्तीशी अमले को सस्पेक्ट को इंटरोगेट करना होता है। सो कस्टोडियल इंटरोगेशन इज वन रिक्वायरमेंट which justifies arrest of a person. Otherwise, Supreme Court in number of cases says, why do you arrest in every case? Arrest is not required. Arrest is don't try to humiliate a person, don't try to put a person into embarrassment or destroy his reputation by rushing to him and arresting only because you have power to arrest. Jokendra Kumar versus the state of Uttar Pradesh, 1994. Supreme Court has warned policemen, all investigating officers, don't rush to arrest. Arrest only in special cases. अब एक वजह ये होती है कि आपको कस्टोडियल इंटरोगेशन के लिए उसकी जरूरत होती है। दूसरी कानूनी वजह ये है कि आपका बाहर रहना समाज के लिए खतरनाक है। You are hazardous. Your presence outside the prison is hazardous to the society's security. You are a threat to society. That is possible in other cases where Aryan case में available नहीं होता है कि जो खतरनाक गुंडा है, जो बार बार गुनाह करता है, जिसके क्रिमिनल एंटीसीडेंट्स हो, उसका बाहर रहना खतरा हो। ये दूसरी वजह है। तीसरी वजह यह है कि अगर जमानत पर छोड़ देने के बाद आप जमानत का दुरुपयोग करेंगे, जैसे अभी आपने फरमाया कि गवाह को तोड़ देना, तो गवाह है ही नहीं, जब एनसीबी के पास नहीं तो आर्यन कहाँ से गवाह तोड़ेगा। इन एनी वे द लॉ सेज if you are likely to temper evidence or threaten witnesses or obstruct the course of justice, your bail can be stopped, can be refused, but not otherwise. Now remember, आपको स्टडी में रखा गया है ताकि आपके खिलाफ जो इल्जामात बनकर आ रहे हैं, उभर के आ रहे हैं, उसमें आप अदालत के सामने रुजू होकर उसका जवाब दें। You face the trial, therefore you have to execute a bond. That's the principle of our criminal jurisprudence.
So then,
bail is never punitive.
So all of
remember.
this, if it doesn't apply to Aryan Khan, Pinky Anand, you can answer the question. Is he paying for his celebrity status?
Now ये देखिए, मैं ये बहुत जरूरी बात आपके चैनल से कहना चाहूँगा कि if a celebrity, one second, if a celebrity, just one second, just one second. एक सेंटेंस, if a celebrity
और अगर उनको डिनाई होती तो मुसीबत, अगर उनको ग्रांट होती तो मुसीबत। इधर भी आप कहते हैं कि सेलिब्रिटी स्टेटस है, इसके कोर्ट ने इस तरीके से किया है या उस तरीके से किया है। देखिए सेलिब्रिटी का अल्टीमेटली कोर्ट कचहरी में जिस प्रकार से होना चाहिए उसी प्रकार से कानून चलना चाहिए। सेलिब्रिटी स्टेटस का कोई मायने अपने आप में नहीं है।
Majeed Memon, you think celebrity status has impacted Aryan? Yes or no?
No, exactly it has. Let me tell you, देखिए, if a celebrity is not entitled to privilege or to an advantageous treatment, at the same time, a celebrity is not liable to suffer disadvantage by virtue of being celebrity, which is unfortunately happening. The reason is media is doing its job. Media is exclusively covering every aspect of the matter, including one left step taken forward by the suspect who is a celebrity. We are seeing this every day in the matters of people who are well known. Therefore, they should not suffer a disadvantage. अब हर एक की नजर लगी पड़ी है, सारे हिंदुस्तान की तमाम अदालतों में वीरान पड़ी होंगी, मगर ये आर्यन की जहां बेल चल रही थी, सारी भीड़ वहां लगी पड़ी थी. This is definitely affecting, even unwillingly, in the mind of the judicial officer. Judicial officer also gets to see that I am in the center of eyes of everybody.
Is that the general impression? Well, we'll debate that. As I thank Majeed Memon, Pinky Anand, please continue with us. Let me introduce our panel tonight. Shweta Shalini, spokesperson of Maharashtra BJP, Shehzad Poonawala, lawyer. Pinky Anand continues to be with us. Also joining us tonight, Sanjay Jha, suspended Congress leader, Shailesh Pandey, Shiv Sena supporter. But my first question goes to Rizwan Merchant, senior lawyer, and joins us on the Newshour tonight. Rizwan Merchant, I want to ask you, is Aryan Khan paying for his celebrity status? Everybody says that because of the media, it puts pressure on the judicial officers. I mean, is that fair?
No, Navika, I would not agree to this. You see, celebrity status is not something which would ever come in the way of a judicial officer doing his duty. in the eyes of law, everyone is the same, whether celebrity or non-celebrity. If a person has come, he deserves to pay for whatever wrong he has done. Coming back to the case of Aryan, right from day one when he was produced before the court, the case of NCB has always been that he is being charged with an offence of 27 for the purposes of consumption, which is a bailable offence. Now, with that particular matter, the matter proceeded before the magistrate, went before the learned sessions judge. In the sessions judge's court, while contesting the bail, they have brought in in the form of WhatsApp chat. Now, if you see carefully the WhatsApp chat, this is dealing with the case of NCB. Whatever is portrayed before the court carries itself with the case which is put up by the prosecution. The case of the prosecution is that there is a WhatsApp chat engaged into between Aryan and some particular person, and the court is made to believe by NCB that this conversation is in relation to trafficking of drugs. Now, first of all, NCB does not know who the person on the other side is. NCB does not know whether he's a trafficker of drugs or whether he's a consumer himself. Assuming without admitting that the person on the other side is a trafficker. If a person claims that, yes, I'm a consumer and I have consumed or I was going to consume, under those circumstances, if you are talking to a person, whether that person is a trafficker or anybody doesn't make a difference. You will be charged with consumption only, because for the purpose of acquisition, you have to get in touch with somebody who is trafficking. If the man is holding as a trafficker even 5 kilos and I'm acquiring from him for my consumption 5 grams, I cannot be charged for the commercial quantity of 5 kilos. I have to be charged only for the offense which I have committed of acquiring 5 grams from him for the purposes of consumption. Now, the court has come to the conclusion that this is a case of conscious possession because he was traveling with Arbaz, and Arbaz and he have stayed that we were supposed to consume together. First of all, when Aryan was boarding the vessel, he did not board the vessel. They took his urine test, they took his blood test, it has answered negative. He was not under the influence of any narcotic substance. Only statement of Aryan was that I was going to consume. There is nothing like going to consume being punishable under the NDPS Act. You have to be a consumer for the purpose of an offense. Now, if this is an offense, then Arbaz and Aryan both will be entitled to the immunity in law to prosecution under section 64 capital A, which is provided by the statute. Now, to prevent that, what is sought to be portrayed before the court is that he is a trafficker. And I'm very, very sad that the learned judge has given a finding in paragraph 34 of the order that I'm not giving him bail because he is a dealer. Where is the question of dealer? Dealer is something which has been dealt with by His Lordship Justice Kotwal in the case of Riya Chakravarti's case. In Riya Chakravarti's case, there was an element of finance in 27 capital A. Therefore, the court held that yes, there was evidence for the purpose of dealing. Therefore, Shovik Chakravarti was denied bail. Under these particular circumstances, at this particular point of time, when you are coming before the court and saying it's a bailable offense, why was he not enlarged on bail? The powers of an NCB officer are the same as the power of a police, as an officer in charge of a police station. If today for a bailable offense, our police officer sitting in the police station as a station house officer can enlarge a person on bail for a bailable offense, why did not NCB use the power of bail and enlarge Aryan on bail at that particular point of time? Why was he dragged to court, made to appear in the court, assuming that he was made to appear in the court? At that point of time, you should have told the court, sir, he's committed a bailable offense of section 27 of consumption, let him release on bail. Just because he's released on bail, that does not mean that your powers of investigation are lost. You could have gone ahead with the powers of investigation.
But the point, Mr. Merchant, is that the court has been satisfied that the NCB's arguments are right. What do you do in such a situation? There is an order. You can only approach a higher court for, a remedy.
It was not the argument of NCB. It was the file that was produced by the NCB before the learned judge, which gave the distance, which gave the detail of the WhatsApp conversation. The WhatsApp conversation has been made the basis by the learned judge for the purpose of rejection of bail, because he feels that on the basis of WhatsApp conversation, NCB is wanting to investigate to find out whether at all that conversation was for dealing and trafficking. To investigate into that. But for the time being, when the man is not in possession, when you're charging him with consumption, you're charging him with conscious possession for the purpose of consumption. Conscious possession was not for trafficking. Conscious possession was not for dealing. It was not for peddling. It was only for consumption. So even if I am in conscious possession for the purposes of consumption, I commit no offense except 27, and which is a bailable offense. It's a bailable offence because 64A provides...
The court didn't think so. The court didn't think so. And Shehzad Poonawalla, you're a lawyer too. And I want to ask you, Rizwan Merchant very passionately saying that it was a bailable offence, but the judge didn't think so. Where do we go from here?
Supreme Court says in...
the problem, now Mr. Merchant, it is my opportunity. Mr. Merchant, you've argued your case quite well, but it is my opportunity, and I hope, like a senior learned counsel, you'll hear the other side. Thank you. Now, the problem with good defense lawyers is that they often consider themselves to be better than the judge sitting in the position, examining the facts and the law before him. And they come to a conclusion even after an order has been given. Now, if you read the 21-page order, Mr. Merchant knows very well that the judge has established that an offence has been made out under Section 29 and Section 37 of the NDPS Act. And for whatever it's worth, the judge has applied his judicial mind in coming to that conclusion. And no, it is not on the basis primarily of WhatsApp chats, but it is on the basis of the fact that even if there was no possession no possession of drugs or contraband on Mr. Aryan Khan's person, it was also the possession with his friend, and perhaps it was possession for a larger trafficking or a larger trading that was happening and over a period of time for which his custody is required and continuation in jail is required. Now, Mr. Merchant also knows that bail is a rule, jail is not. That is true. But when you are under Section 29 and 37 of the NDPS Act, an act like NDPS Act, the presumption of innocence shifts and there is a presumption of guilt. Of course, it is rebuttable presumption of guilt, but it is then incumbent upon the person on whom the accusation has been made to actually show that prima facie he absolves himself of that accusation, which, by the way, the defendant in this case has not managed to do at two forums. One at the forum of the magistrate, where they could not argue that the punishment was less than a period of 1 year or the sentencing was less than a period of 1 year. Then they came to the special court, where they have again failed after this prolonged hearing that this prima facie case is not made out. Now, I want to ask Mr. Rizwan that you have another forum, High Court. I am not saying Aryan Khan is guilty, but stop peddling the narratives that are coming out. Mr. Shavik, the brother of Riya Chakravarti, was given the exact same treatment. Many people are given the exact same treatment. The similar amount of drugs or lesser amount of drugs are got from them, or maybe no drugs are recovered from them, but because they are in constant touch with a particular peddler or with a particular dealer, they are subjected to the rigors of the law. But you or some of your ilk believe that because somebody happens, one second sir, somebody happens to belong to a certain family, he should be treated differently. Just because he happens to be Mr. Aryan Khan, emphasis added, we should suddenly treat him with soft gloves or kid gloves. That's not how the law of this country works, sir. And so what about the kind of narrative that is being built up about the NCB?
Many people are saying that, is the law same for everybody? Well, on one side we have Aryan Khan, many people are questioning whether he's paying for his celebrity status. On the other hand, many people are saying just because he is Aryan Khan, should he be treated differently? Where do you stand on this?
Well, Navika, actually, I'm very glad that you're discussing the Aryan Khan issue today in your show, because I think this is not just about, legal experts pontificating on which way the law should be interpreted. This is about the actual impact on the ordinary citizens of India. Now, I have done enough homework in law for a considerable period of time to tell you that presumption of innocence, and I'm glad you mentioned it at the beginning of the program, is the foundation of any modern jurisprudence. In fact, if one goes back to Justice Krishna Iyer's verdict in the state of Rajasthan against Balchan in 1977, where he was very categorical that bail and not jail should be the way by which you should look at the accused, that has actually then onwards become a precedent. Now, let me tell you the problem. If you notice, in the last couple of years, the Supreme Court has acquitted many people under very harsh laws, including TADA, UAPA, etc., by upholding Article 21, upholding the rights of the accused, and protecting civil liberties and personal freedom. The problem, Navika, is this, that the Supreme Court is not yet laid down, or it needs to lay down categorical guidelines, because the courts at the lower end of the judiciary clearly do not understand it, which is why you find despite the fact that the law on sedition is so clear that unless you are provoking public disorder or creating violence or calling for an kind of an agitation against the government and the military, you haven't committed an act of treason. And yet people are arrested for sedition charges at the lower level. And the process is the punishment. I think what Harish Salvi said is so true, that end of day, Aryan Khan will get a bail at some point. And the point is the harassment, the nightmare will probably last years longer. This is the tragedy of our system. And I want to make one point here. You are absolutely right. This is a case of a celebrity harassment. I'm not commenting on the case. That is sub judice, fair enough. Let the merits of the case dictate what happens to Aryan Khan. But there cannot be denied that there's been a bigger story of a heroin seizure of 21,000 crores, 9,000 kilograms in a Mundra port in Gujarat in September 2021, which we are not even talking about. We are talking about Aryan Khan and his supposed intent to consume, but nobody is talking about a massive import of heroin in this country worth 21,000 crores that, frankly speaking, ought to be the obsession of the government and of the people who are in charge of controlling narcotics in the country. That is the hard truth. And we can't run...
Shweta Shalini, pertinent point being raised by Sanjay Jha, and let me add to that the question. The order is that the accused might just come out on bail and tamper witnesses. In this case, the joke is that the witness is on the run. NCB also doesn't know where he is. And nobody is talking about the large quantities elsewhere. हम 5 ग्राम हेरोइन के पीछे पड़े हुए हैं और लोगों की यहाँ पे आर्ग्यूमेंट है कि that's because he is Aryan Khan and celebrities have to pay the price of being celebrities. Respond to that charge.
Navika, there are 3 things that I want to say and answer to Sanjay ji. One, because he's been expelled from Congress, probably he's forgotten that in 1985, the NDPS Act was passed by the Rajiv Gandhi government. And at that point of time, it was clearly mentioned in the NDPS Act that irrespective of everything, this is an act which will ensure that the suspect is guilty unless proven innocent, unlike other laws. Now, for here, if you actually look for Aryan Khan's case, now Sanjay ji has categorically said that, larger quantities of, contraband has been found in Mundra port, but we are not talking about it. Now, who's not talking about it? The media is not talking about it. The mere fact that it has been found and cases are going on, people are getting arrested, it means that the NCB is doing their task. The agencies are on their job. But Mr. Sanjay Jha and the other Congress leaders are not interested in fact, the media is also not interested in knowing exactly what happened. There are 20 people who have been arrested even in this case. 5 of them have been dealers. Navika, please note that Aryan Khan and Arbaz both named a person called Achit Kumar, who has been dealing with, who's been a dealer, who's an established dealer. And both of them have pointed out there have been chats which talk about bitcoins. There have been chats which talk about a lingo which ensures that there is international interactions. And hence, Section 29 has been clearly invoked, which means that the entire chain will be tracked, traced, and for tracking and tracing that, a complete watertight case has been made by NCB. A little while ago, I think 2 days ago, I found the same people on different panels, Majeed Memon ji talking about there are no WhatsApp chats. It has been cooked by NCB, but evidence has been presented and the courts are satisfied. Yes, there is an opportunity. He can go to the High Court and probably he'll get a bail because I'm sure that is his right. But then, as of now, if we stick to today's judgment, it has been proven in 36 paragraphs that the judgment clearly says that NCB is right. There is a watertight case. They have found evidences. Yes, they will corroborate it and find out more evidences. And that's exactly why they want him in further custody.
शैलेश पांडे जी, मैं आपसे पूछना चाहती हूँ, अगर NCB ना पकड़ता तो दुनिया कहती अरे सब मिले हुए हैं, सब मिले हुए रहते हैं, कभी बड़े लोगों को तो इस देश में पकड़ा नहीं जाता. लोग अक्सर यही कहते हैं, कभी बड़े लोगों को पकड़ा नहीं जाता. अब एनसीबी पकड़ती है और कोर्ट उसको सही ठहराती है, तो सवाल ये है कि बेचारे आर्यन खान सेलिब्रिटी हैं, तो उनके साथ ऐसे हो रहा है, वैसे हो रहा है, पॉलिटिकल षड्यंत्र है, तमाम तरह की चीजें कही जा रही हैं। मैं आपसे पूछना चाहती हूं, अगर कोर्ट में जज की ऑब्जर्वेशन ये है और उन्होंने कहा है कि यहां डीलिंग की बात है, सो आई अज्यूम paragraph 25 says applicant appears to be an important link in the chain of drug dealers. He was in touch with different dealers. He had monetary transactions with them. Disclosures by each of them has led to discovery of involvement of others. Hence it is not desirable to release the applicant. तो कहीं ना कहीं जज सेटिस्फाई होंगे, शायद सारा एविडेंस यहां साइटेड नहीं है लेकिन कोर्ट में पेश किया है एनसीबी ने. व्हाई आर वी डाउटिंग द एनसीबी ऑलरेडी?
देखिए नोविका जी, मेरा ये स्पष्ट तौर से कहना है कि कानून अपना काम करता है, कानून सभी के लिए एक समान होता है, कानून न किसी सेलिब्रिटी के लिए न आम आदमी के अलग होता है. लेकिन होता क्या है इस केस में, जो एनसीबी में शुरुआत में जब वहां पर रेड पड़ी तो ये दो प्रश्न उठे थे कि ये जो पार्टी वहां हो रही थी इसको ऑर्गेनाइज किसने किया था. तो ऐसा कहा जाता है कि वहां कोई बीजेपी से संबंधित कोई व्यक्ति था जो ऑर्गेनाइज किया था. प्लस उसके बाद एनसीबी ने कुछ एक दो लोगों को छोड़ दिया था, तो उस पर भी प्रश्न चिन्ह लगा कि जो कि बाद में पता चला कि ये भाजपा के कार्यकर्ता थे. तो बाद में ये भी चर्चा हुई कि किसका फोन आया था, किस पॉलिटिकल लीडर का फोन आया था, किसके कनेक्शन में, किस बीजेपी नेता के कनेक्शन में ये लोग थे जो छोड़े गए. तो ये तो कहीं ना कहीं लगता है कि एनसीबी भेदभाव की भावना से काम किया है. और मुझे ऐसा लगता है ये, देखिए मैं ड्रग्स लेने इसके खिलाफ हूं, मेरा व्यक्तिगत ये है, और वो कोई भी व्यक्ति हो, बड़ा हो छोटा हो, कानून सबके लिए एक समान है. लेकिन इस केस में जो होना चाहिए वो सबके लिए एक बराबर होना चाहिए था, वो नहीं हुआ है. इसलिए कहीं ना कहीं ये प्रश्न चिन्ह लगता है. और अभी अभी जो गुजरात का विषय उठा, गुजरात में भी हजारों करोड़ के ड्रग्स पकड़े गए, लेकिन उस पर तो इस तरह से चर्चा या इस तरह से जो भी बातें होनी चाहिए थी, जो कार्रवाइयां होनी चाहिए थी, उस पर तो कार्रवाई नहीं हुई. उस पर तो भारतीय जनता पार्टी ने हाय तबाह नहीं मचाया. उस पर तो जो भी जितनी और फास्ट बातें मीडिया में आनी चाहिए थी, लोगों को जानकारी मिलनी चाहिए थी, वो नहीं मिली. तो कहीं न कहीं ये लगता है कि ये,
वैसे मैं आपको बता दूं शैलेश पांडे जी, आमतौर पर कॉन्ट्राबैंड सब्सटेंसेस, स्मगल्ड गोल्ड, इस तरह की चीजें कई एयरपोर्ट्स पे भी मिलती हैं. आपके स्टेट में भी मिलती हैं, दूसरे स्टेट्स में भी, दिल्ली में भी मिलती है. तो जो ओनर होता है एयरपोर्ट का, उसको नहीं बुलाया जाता, नॉर्मली कस्टम्स डील करती है. लेकिन शालिनी जी जवाब दीजिए कि बीजेपी के विटनेसेस, बीजेपी के कार्यकर्ता वहां क्यों थे और क्या कर रहे थे और अब गायब क्यों हैं?
नविका जी, पहली चीज तो मैं याद दिलाना चाहूंगी, बेल की बात कहती हूं शैलेश जी को. देखिए ऐसा है, हमारा एक कार्यकर्ता था जिसका नाम समित ठक्कर था. उसने माननीय मुख्यमंत्री के खिलाफ कुछ बात कह दी थी, उसके लिए उसको 23 दिन तक जेल में रखा गया. तो क्या बेल मिला? हाँ मिला, लेकिन 23 दिन फिर भी जेल में रखा गया सिर्फ सोशल मीडिया पे कुछ कहने के लिए. ये तो एनसीबी का मामला है जहां पर ड्रग का सेवन और पेडलिंग की बात है. दूसरी चीज विषय बिल्कुल नहीं शैलेश जी, देखिए हम ऐसे लोगों में से नहीं है. हमारे कार्यकर्ता को यदि पता चला कि वहां पर खरीद बेच हो रहा है, हमारे घर में हमारा दामाद जब वनस्पति बनाता है ना, तब हम बैठते नहीं है घर पे. हमारे कार्यकर्ता को भी जब पता चलता है कि वहां पर खरीद फरोख्त हो रहा है ड्रग्स का, तो वो जाकर एनसीबी को इन्फॉर्म करता है. और यही अंतर है शैलेश जी आप में और हम में. वेरी गुड, इन्फॉर्म करता है तो अच्छी बात है, फिर गायब क्यों हो जाता है ये समझा दीजिए. गायब कहाँ है? आप बुला लीजिए, आपके चैनल पे आ जाएगा नविका जी, आप बुला लीजिए, आपके चैनल पे आ जाएगा. ये लोग शैलेश जी को बोलिए जाके इंटरवेंशन पिटीशन फाइल कर देंगे, वो कोर्ट में चला जाएगा. एनसीबी हैज ऑलरेडी कम फॉरवर्ड एंड सेड that we have followed the law and if questions will be asked in court, we will answer.
Now, Sanjay Jha,
there is so much.
Sanjay Jha raising his hand. Sanjay Jha, categorical offer being made by Shalini ji here, Shweta Shalini, that witness not absconding will appear the minute he is called either by Times Now or by the court. Respond to that.
Navika, let me tell you this very categorically. In several press conferences, Mr. Nawab Malik, and I happen to know Nawab Malik quite well. Nawab Malik is not somebody who's going to make an irresponsible statement very casually. In fact, Nawab Malik has given enough evidence in the public domain of people who have been very close proximity to BJP leadership, people who have got actually a BJP official role in the past and maybe even currently, who were found to be around when the entire raid happened on the ship or the cruise where Aryan Khan was arrested. I think to my mind, Navika, that is a very serious issue, because you see what is concerning a lot of ordinary people in India, and I met some people today who said, are we living in a time when political vindictiveness, where maybe a government or a political
But that's an assumption, and Shehzad Poonawalla, I want to ask you, and I want to ask you this categorically, Shehzad Poonawalla, if the BJP had to orchestrate something, would they be so naive so as to put their karyakartas in front so that they can get caught and get filmed on cameras? Even that's a question.
Yeah. So look, I don't want to get into the intelligence of the BJP in playing devious, dirty games if they want to, but I have trust and faith in the integrity of my courts, and I certainly don't think that the courts of this country are an extension of the Sangh Parivar or the BJP. Let's assume the NCB has done the bidding of the political masters of the time, but in a court of law, and even the worst of critics of the Modi government will acknowledge, and I'm sure Mr. Rizwan Merchant, officer of the court, will acknowledge that even to make that kind of scandalous allegation against the court is not fair, because the court will not decide on what the government thinks, what BJP thinks, what Shweta Shalini thinks, what the NCB thinks. It will only rule on what the facts are and what the evidence and the law says. But I have another question for Mr. Sanjay Jha. First of all, Sanjay, you're wrong. There is no presumption of innocence in the NDPS Act. Mr. Merchant will educate you. The presumption of innocence shifts to presumption of guilt. It is rebuttable, and which has not been done by the lawyers. But I have a question for you and show you how you change your principles according to convenience. You said bail is the rule and jail is the exception. For Mr. Mishra's son, who also happens to be a celebrity's son because his father is a union minister of state, you wanted the man to be put in jail the next moment. This 1 second, do not interrupt. Let me finish. You wanted the man. Yeah, please don't interrupt. But be
calm down.
You wanted the yeah. So first you stop interrupting. Let me complete my point. Let me complete my point. You wanted Mr. Mishra in jail forthwith, without a shred of evidence, and till date there is no video of him being at that location. You did not have the same principle that bail should be the rule, jail should be the exception, in a place where there is actually presumption of innocence.
Okay.
But in a case and a law where there is no presumption of innocence, you want Aryan. Now 1 second, let me complete.
Sanjay Jha responding, I'm running out of time. Sanjay Jha responding to Shehzad Poonawalla.
Yeah. Mr. Poonawalla, let me answer you. Look at the audacity or the shamelessness of the proposition. Here is a man who's accused of sitting in a jeep, allegedly, and crushing farmers to death. My dear friend, are you comparing a man
accused of running an international trade drug racket?
In the middle.
A man accused of international drug racket.
Do not speak in the middle. Calm down. Even I can raise my voice. Do not take advantage of my decency.
Do not shame us with the shamelessness of your proposition.
Calm down. Don't raise your voice here.
All right.
Double standards of your
closing point. 10 seconds to Sanjay Jha. 10 seconds to Sanjay Jha.
Here is a man who crushed allegedly farmers to death. And that is being compared to a 23-year-old young man who allegedly wanted to consume some drug. I mean, this is preposterous, absurd.
The only difference being, in one case, you're being the judge, jury, and giving the faisla. In the other, it is the court which has given the faisla. We'll have to follow the due process of law. In the case of Mr. Mishra's son, well, whether he's innocent or guilty is only something that time will tell when the matter comes up in court. In the Aryan Khan case, the court has given its verdict. Yes, it's for a 23-year-old. Sounds terrible at this point, but it is a court, and the only remedy lies in a higher court. Is it just? Not just? Yes, we will continue to debate it. We know this is a very, very life-altering position for Aryan Khan, but at the same time, only the courts can decide on this. Thanking all my guests on Newshour Debate number 1.